Hi, my name is Andrew. I'm the founder and owner of IBIS Prep, and today I'll be teaching about secured transactions for the Florida bar exam. I like to begin my lectures with a little bit about my business and a motivational quote. And today I'll begin by introducing Jeremy, who is one of our instructors. Jeremy, an amazing professor. You'll recognize him from the Florida family law video and the Florida and federal civil procedure videos. So if you want to work with Jeremy, you can feel free to reach out to any of us at IBIS Prep. More specifically, Alexis or Simran, who will set you up with any one of our great instructors for the bar exam. The motivational quote today comes from the Dalai Lama, who actually gave a commencement speech at my undergrad university the year after I graduated. That's a Tulane University in New Orleans. And his quote is, "Judge your success by what you had to give up in order to get it." Great quote. Some people, things come easy, and some people they don't. And don't look to the person next to you to define your version of success. Look inward to see what you had to give up in order to get it. And that's a really good measure. So keep pushing and do your best. And let's learn a little bit about secure transactions today. So I always like to begin by just a general overview of how I would approach a secured transactions essay. And I think the key part is identifying that we're in the world of Article 9 and we're talking about secured transaction. A secured transaction is very similar to the way that a mortgage operates. It's just not about real property. It's about personal property. Specifically, it's about tangibles or intangibles. The four types of tangibles are consumer products, farm goods, inventory, and equipment. Then there's tangible intangibles like chattel paper or commercial paper. And then there's intangible intangibles like electronic chattel paper or accounts receivable. So we have identified that there is a secured transaction issue, usually by the word collateral or secured by or the secured party or consignment or some type of word that shows a debt that's tied to a piece of collateral. So we first identify that we're in the world of Article 9. Then we determine what type of collateral is being offered up for security. And then we just go through the process of attachment, perfection, and priority. Attachment is usually going to be through a security agreement, unless it's oral, which will create pledges. The security agreement needs to have the necessary terms, signed, written, well, if it's a security agreement, written, identifying the collateral and the parties. Whereas a oral agreement is simply by possession or control of the collateral. Usually we see that with accounts receivable or things like that. So after we've determined if there's attachment, the next step is perfection. Now, perfection usually happens through a financing statement, which is similar to a security agreement. It's just a little bit more procedural and is actually filed with the Secretary of the State. And this will put the world on notice of your interest in the collateral. In case there's multiple parties who have interest in the same piece of collateral, we want to have a notice of all of those interests. And we do that through a financing statement, which will also include the names of the parties, identify the collateral, and be signed and written and filed with the state. So we have that financing statement. We also have what's known as a PMSI, a purchase money security interest. And a PMSI is a lot like a PMM in the sense that, remember, purchase money mortgage from real property, in the sense that the PMSI is going to have priority over every other secured interest party, because the PMSI is a loan that's where the money is used to purchase the collateral itself, like the TV. You take out a PMSI and buy the TV. Well, the person who gave you the loan retains priority interest in that television because they have a PMSI. In consumer goods, there's automatic perfection upon attachment. And then there's a grace period of 20 days for non-consumer goods where there will be perfection. As long as you perfect within 20 days, then you will be first and right. There's also a temporary perfection to proceeds of consumer goods for PMSIs. So again, reeling it back a little bit, are we in Article 9? Is this a secured transaction? Do we have a piece of collateral that's one of the 4 tangibles: inventory, equipment, farmer goods, or consumer products? Or is it intangible? Is it tangible, intangible, or intangible, intangible? Let's just identify it. Identify the security agreement, which creates attachment. If it's oral, they'll create pledges. Identify the financing statement, which will determine priority. Unless it's a PMSI, it'll be automatic. And then we look to priority. Remember, PMSI always senior priority. After that, it's first to perfect. And then after that, it's just first in time. So perfected will be first to file. Perfected versus unperfected, perfected always wins. Unperfected versus unperfected, first in time, first and right. So it's usually gonna be first in time, first and right, unless we have a situation where it's a PMSI, or if it's perfected versus unperfected. A perfected interest, even if it occurred after unperfected, will have priority. So we have those four, we have those 4 examples of different types of interest and how priority will go. PMSI number 1, perfected, first in time, first and right. Perfected versus unperfected, perfected always wins. And then unperfected versus unperfected, again, first in time, first and right. And then after the process of determining priority, we simply look to, well, how can they recover if there's a default and they don't, they need to get their collateral back. Well, you can get the collateral back yourself, but you cannot breach the peace. And instead of breaching the peace, you would actually need to receive a writ of replevin from usually the sheriff, who will go over and actually recover your property. So in a nutshell, that's secured transactions. We just see what's the collateral, we identify the parties, identify the security agreement that creates attachment, identify the financing statement that creates perfection, and then the list of priority. And just like in commercial paper, we were looking out for a holder in due course. In secured transactions, we're looking out for a PMSI, similar to the PMM in a mortgage. Then we determine priority. And then remember, we cannot breach the peace. We can recover our collateral without breaching the peace. Then we would need to seek a writ of replevin. So let's take a look at secured transactions in my drive and see if I missed anything or if what we need to know. I feel for my PowerPoint is pretty solid because I've delivered this PowerPoint a few times. Article 9 applies to any transaction that creates a security interest in personal property or fixtures by contract. Agricultural liens and interest in farm products that secures payment for goods or services furnished. Consignment, the definition of consignment, giving a merchant goods but not legal ownership with the expectation the goods will be sold. We think of consignment like a pawn shop. Certain lease agreements as collateral for goods. Be careful with a property lease. Landlord liens are not under Article 9. The security agreement. A security interest is created by a written security agreement or by taking possession, delivery, or control of the collateral and attachment. A security agreement is an agreement that provides a security interest in certain collateral. A financing statement is the document that is filed to serve notice of the security interest. It must be authenticated. A written agreement is necessary unless possession or delivery or control. And when there's no written agreement, the oral agreement creates pledges who have an interest in the security. The types of collateral: tangibles, consumer goods, inventory, farm products, and equipment. Oh, we want to consider, are they fixtures? If they're fixtures, they're part of the real estate, and Article 9 is not applicable. Also, the difference between accession and commingled: either one of these would not be severable. Accession is kind of like a tire on a truck or on a bike. You can still identify the tire, but it's become affixed to something else that it wouldn't be reasonable to dismantle it. Whereas commingled, you think of, like the copper on a penny, or the stock in a soup. I mean, these are terrible examples, but just so commingled that you can't even identify them. And then intangible, tangible, intangibles, written instruments or documents or chattel paper. And then intangible intangibles are accounts receivable, towards claims, and general intangibles like software. Attachment is the process by which the security interest is created. Attachment requires the secured party gives value. The bank lends $20,000 to buy a car. The debtor has rights in the collateral and power to transfer the rights. Kim goes and buys the actual car. So there we see it's a PMSI, right? Because she used the money to buy the car. The debtor, so we have the secured party and the debtor, the names of the two parties. The secured party is the one that gives value, and the debtor is the one who borrows. The debtor has authenticated a security agreement that sufficiently describes the collateral. Kim and the bank sign an agreement that grants the bank an interest in the collateral and sufficiently describes the collateral. PMSI, PMSI, PMSI. PMSI is a purchase money security interest. The TV you want to buy will be the collateral if you default. The goods are purchase money collateral. The debtor incurs a purchase money obligation. A PMSI in goods, we'll say, will have automatic perfection upon attachment. And like I said, and a perfected PMSI in goods or software will prevail over conflicting interests. Second time, first and right. Perfection is the process by which the secured party gives notice to the world of its security interest. Perfection is necessary for priority. Means of perfection, we have filing, the most common method. Possession, negotiable instruments in Article 3, chattel, goods, etc. Control, investment securities, deposit accounts, electronic chattel paper. Automatic permanent perfection in PMSI consumer goods. Automatic temporary perfection to proceeds. PMSI in non-consumer goods will have that 20-day grace period for perfection. Here's a couple of points about the filing statement. Florida requires notice. A filing statement must be filed, usually in a public office and held in the Florida registry. The necessary information is the name of the debtor, the name of the secured party and the secured party's representative, and description of the collateral. Florida requires certificate of title for motor vehicles. Most financing statements are effective for 5 years. A continuation statement must be filed within 6 months of termination date. So Florida requires certificate of title for motor vehicles. Let's not forget that. And the duration of a financing statement is 5 years, and then 6 months of the termination date within you have to file for continuation. So look out for that for a lapse of a financing statement. Priority, first in time, first in right, except unperfected versus unperfected, first to attach. Perfected versus unperfected, perfected always wins. Perfected versus perfected, first to file. And then PMSI has second in time, first in right. A lien creditor has acquired interest in the property by attachment or levy and is treated as perfected by definition. If a debtor defaults, the secured party has the right to repossess. If a secured party cannot recover the goods without breaching the peace, it may need to bring an action for a replevin. And this YouTube video is Homer Simpson telling Lisa that unless she has an active replevin, he's taking this little car on a joyride. Never bend your head, always hold it high, and look the world straight in the eye. Very powerful quote coming from Helen Keller, as you know, she had an interesting perspective on life. So, you know, that's an easy transaction. Identify the security instrument under Article 9, identify the type of collateral, look at the security agreement, consider attachment, PMSI, PMSI, perfection, financing statement, priority, and default. Very, very easy singular outline we can master. Let's look at the rules here for secure transactions. I like these rules. Secure transactions under the UCC, Article 9 refers to personal property, not real estate. UCC governs under Article 9, an interest in personal property or fixtures that secures payment or performance of an obligation. That's a security interest. An agreement is consensual agreement that provides for security interest. We have the parties, the creditor / secured party, person in whose favor security interest is created, so the lender. The obligor, the person who must pay or otherwise perform with respect to the obligation secured by security interest. And then the debtor, the person who has an interest other than security interest or other lien in collateral such as its sole owner. The debtor is usually also the obligor. So the debtor and the obligor is the one borrowing the money. The secured party / creditor is the one lending. The type of collateral usually determines the priority of claims. Rosie, stop. There are 4 types of collateral in secured transactions: equipment, inventory, consumer goods, and accounts. Equipment is anything used in business other than inventory and farm products, i.e. eggs, crops, cows, etc. Those are going to be farm products. Inventory are goods held for sale or lease. Consumer good is anything used primarily for personal, family, or household use. And finally, accounts are right of payment for goods or services, not evidenced by an instrument. If tangible property can be placed in more than one category, the primary use of the debtor puts the collateral at the time the interest attaches. It'll determine the type of collateral. So collateral project is security interest. We have goods, movable items, consumer goods or family or household, inventory, items for sale, farm products or animals, crops, etc. It doesn't include equipment like tractors. And then equipment would be like tractors, machinery, anything not in other categories. Common non-goods, we have semi-tangible and intangible. Deposit accounts, investment property, documents, instruments, shadow paper, they're general intangibles. And then a promissory note, an instrument that evidences a promise to pay a monetary obligation. You see how a promissory note can be used as collateral. And that's a great way for the Florida Bar to test Article 9 and Article 3 in one essay, is to have a promissory note that's put up as collateral. Security agreement, an agreement that creates or provides for security interest in a general collateral. To create, it must be in writing, authenticated, signed by the debtor, contain a granting clause, and description of collateral. The secured party gives value. The debtor has rights in the collateral. The debtor authenticates a security agreement, which clearly describes the collateral. The description of collateral using UCC language / terms to describe collateral is appropriate. A mere contract to repay a loan over a set period is not a secured interest. Or is not a security agreement. A written security agreement is necessary for creation of a security interest unless the secured party has possession of collateral. Where secured party has possession, all that is needed is an agreement, which can be oral, that the secured party is to have a security interest. A security interest in this manner creates a pledge. With certain types of collateral, control takes place of possession. A security agreement may be evidenced by control if collateral is in a deposit account. A security interest in collateral also extends to identifiable proceeds of collateral. A secured party may have security interest in both original collateral and identified proceeds of collateral. A valid security agreement is generally binding between parties against purchases of collateral and against creditors. Attached, a secured party debtor relationship. Attachment is an arrangement that links the debtor with a piece of collateral. Just upon attachment that the security interest becomes enforceable, there are 3 rights for attachment: the value given by the secured party, the debtor has rights on the collateral, and there's a security agreement that must be authenticated by a record that describes the collateral or the secured party has possession or control over it. Once security interest has attached, the secured party has all the enforceable rights provided by Article 9, including right to repossess collateral upon debtor's default. To create a security interest in after acquired collateral, security agreement must specifically provide for it. The debtor grants to secured party a security interest in all debtor's equipment now owned or hereafter acquired. Equipment that debtor acquires after security interest is signed will be covered by secured party's security interest because there's an after acquired property clause. A security agreement specifying an interest in inventory or accounts receivable creates an interest in after acquired collateral, notwithstanding absence of an after acquired property clause. Regarding consumer goods to be effective, a security interest in after acquired consumer goods requires that the debtor acquire rights in consumer goods within 10 days of the secured party given value. Accessions are goods that are physically united with other goods such that the identity of the original goods is not lost, as opposed to commingling, where the original identity is lost. Security interest created in collateral that becomes an accession is not lost due to collateral becoming an accession. Also, a security interest can be created in collateral that is an accession. Number 4, perfected. In order for a secured transaction to be perfect, it must first be attached. Perfection is a process that serves as constructive notice to third parties, assuring the secured party their priority over later creditors. There are 3 main methods of perfection: by filing a financing statement with the Florida Secured Registry, by possession, tangible property, money, goods, negotiable documents, etc., or by control, tangible property, deposit accounts, electronic documents, and by automatic perfection. Automatic perfection occurs when the security interest is perfected without any filing, possession, or control. The most common is a PMSI, a purchase money security interest of consumer goods. Attachment plus filing of financial statements is the most common way to perfect. Filing can be done in the state of Security of State's office, or when collateral consists of fixtures, in the office of the county clerk, in a county where land to which collateral is attached is located. A financing statement. Perfecting a security interest by filing a financing statement with Florida Security Transactions Registry makes it valid against other creditors. Must include the name of debtor, the name of the secured party or representative, and description of the collateral. A super generic collateral description is insufficient, whereas this would be sufficient in a security agreement. Ultra generic is not going to be sufficient in financing statement. Not sufficient as a security agreement unless the financing statement itself or some other writing contains a granting clause indicating that the debtor intends to give a security interest to the secured party. If contains minor errors, it will still be effective unless errors make financing statements seriously misleading. A filed financing statement is effective for 5 years after the date of filing. To be timely, a continuation statement must be filed within 6 months before expiration of the 5-year period. Florida perfection for motor vehicle, the lien must be noted on the vehicle's title. A fixture filing statement must contain all the required that's in a financing statement, indicate it covers fixtures, indicate that it's to be filed in real property records, provide a description of real property which fixtures related. Possession, taking possession of collateral is possible when only collateral is tangible. Attachment plus perfection will perfect the security interest in goods, negotiable instruments, money, or tangible chattel paper. Negotiable documents, instruments, money, or tangible chattel paper. A secured party who has taken possession of collateral must use reasonable care in its custody and preservation. Reasonable expenses incurred in custody and preservation may be charged to the debtor. Investment property. Possess stock certificate with endorsement if necessary, or if stock is registered, then become named stock owner on registry, or if stock is held through securities intermediary, then become named owner on intermediary's registry, or enter into agreement with issuer of stock or securities intermediary to change registry name at later date upon request of creditor. Deposit accounts can only perfect by control. There's 3 methods. The creditor becomes the bank customer's on account, the bank maintaining an account, or a tripartite agreement with bank maintaining account, creditor and debtor, the bank will comply with creditor instructions. Letter or creditor of right can only be perfected by control and electronic chattel paper. So these are just different ways of perfecting where you don't need to actually file a financing statement because it can be done by possession or control. Control of tangible collateral, possession of tangible collateral and control of investments. We talked about the automatic perfection. Occurs when the security interest in a PMSI is in consumer goods, which perfects upon attachment. PMSI, seller finance PMSI, secured party sells debtor collateral on credit and retains a security interest in an item sold. Enabling loan, a loan to debtor that enables debtor to buy specific collateral and creditor takes security interest in specific collateral and credit, or loan proceeds must be used to acquire collateral. For PMSIs and collateral that's not a consumer good, you have a 20-day grace period for filing. If filing occurs within that time, perfection relates back to the date security interest is attached. And then you have automatic temporary perfection incurs in a perfected security interest for proceeds. Proceeds is perfected when security interest on literal collateral is perfected, but only temporarily. The auto perfection for proceeds continues only 20 days after attachment. If financing statement is filed within 20 days after debtor receives delivery of collateral, perfection relates back to the secured interest attached upon debtor's receipt of collateral. If the security interest is perfected by one method and later perfected by another, security interest is perfected continuously so long as there's no intermediate period of being unperfected. And then priority. Secured creditors have priority over unsecured creditors. And between secured creditors, perfected creditors have priority over unperfected creditors. In a dispute between perfected creditors, a perfected PMSI has super priority. If none are PMSI, then the first in time to file / perfect takes priority. A perfected secured creditor has priority over a lien creditor, but the lien creditor has priority over the unperfected secured creditor. If the lien is a statutory lien, then the lien holder has priority over the secured and perfected creditor. The general rule / flight rule among secured creditors, first to file perfect has priority. The basic rule among secured creditors, first to file perfect has priority. Super priority in consigned goods. A perfected PMSI security interest in goods other than inventory or livestock has priority over conflicting security interest in the same good if the PMSI is perfected when the debtor receives possession or control or within 20 days thereafter. If the PMSI holder in non-inventory has priority over the person who got there first, if it's perfected when the debtor receives possession of collateral or filed within 20 days of the debtor receiving it. Unperfected versus unperfected, first in time. Perfected versus unperfected, perfected always wins. Perfected versus perfected, first in time. Lien creditors versus secured parties, first in time, first in right applies to priority contest between lien creditors and secured parties. We're going to treat them as perfected. A lien creditor is a creditor that has acquired interest in a property by attachment, levy, or like. A special rule for PMSIs, if PMSI is perfected within 20 days after debtor receives collateral, PMSI will take priority over a lien creditor whose interest arose in intervening period. Special rules for fixtures. For fixtures, the only way that secured creditor can obtain priority over mortgage is by filing a fixture filing before the mortgage is recorded. If a security interest in a fixture is a PMSI, then second time, first and right priority applies so long as the security interest is perfected by a fixture filing within 20 days after good becomes a fixture. Priorities, buyer versus perfected security interest. Unless a secured creditor authorizes a free and clear sale, the buyer takes a property subject to the perfected security interest. Exceptionally, when the buyer is under ordinary course of business or he is a consumer garage sale buyer, he buys for value for his own use or family or household from consumer seller without knowledge, then the buyer will take the property free and clear regardless of perfected security interest. Garage sale exception can be avoided when a PMSI of consumer goods by filing a financing statement, which they're not required to because the perfection is automatically. And then we talk about what happens in a default. Default occurs when debtor fails to tender an obligation when due, and upon default, a secured party may reduce a claim to judgment, foreclose, or otherwise enforce claim. Upon default, a secured party has the right to repossess tangible collateral if it can do so without a breach of the peace. If a secured party cannot obtain collateral without a breach of the peace, the secured party must bring an action for replevin. This means that a sheriff can seize property for secured party when court issues a writ of replevin. Repossession, upon default, a creditor has a right to repossess collateral, dispose of it, and apply proceeds. There's three types. Constructive security allows a party to render equipment as not usable and to dispose of it on debtor's premises rather than removing it. Self-help is go ahead and take it. You just can't breach the peace. And a judicial action, a party may seek summary judgment, judicial action / replevin. You have a right to repossess superior to that of debtor. Before collateral is foreclosed upon, debtors have a right to redeem collateral by tendering to the secured party total amount of obligation, including interest plus reasonable expenses and attorney's fees. Debtors must seek / achieve redemption before collateral has been collected. Secured parties dispose of collateral or is entered into a contract for its disposition, or secured parties accepted collateral in full or partial satisfaction of obligation. After default and repossession, a secured party may sell, license, or otherwise dispose of any or of all collateral in its present condition or following any commercially reasonable preparation or processing. Cash proceeds of collection, enforcement, or disposition are applied. The first to reasonable expenses of retaking, holding, preparing for disposition, processing, and disposing of collateral, and reasonable legal fees and expenses incurred by secured party. Second, satisfaction of obligations incurred by secured interest under which disposition is made. Finally, satisfaction of obligations secured by any subordinate security interest in or other subordinate lien on collateral if the secured party has received an authenticated demand before disposal. If collateral does not bring enough at a sale or judgment to pay for all outstanding obligations, a secured party is entitled to a judgment for the deficiency. If a sale is conducted in a commercially unreasonable manner, that deficiency can be reduced. All right, super thorough rules. Last thing I'll look at is this outline. Pretty much the same thing. I'll go over it a little bit quicker, but I'm sure it's all the same thing. UCC, security interest. We have the creditor and debtor, collateral in these consumer goods, inventory, farm products and equipment, common non-goods or deposit accounts, promissory notes. Security interests, literally these exact same things. Attachment, perfection, and priority. So they pretty much the exact same outline. So nothing too crazy here. And let's see how it was tested on an essay. What points did we need to mention to crush an essay? A security interest is an interest in collateral that arises under Article 9 of the Uniform Commercial Code. In order to be valid, a security interest requires a security agreement, attachment, and perfection. A security agreement must be authenticated writing, contain words of grant, and reasonably describe the collateral in sufficient terms. Ultra generic terms are insufficient, however, generally UCC terms are fine. Attachment forms a link between the security agreement and the collateral itself. Attachment occurs upon the later of when the debtor has rights in the collateral, the creditor gives value for the transaction, and the execution of a valid security agreement. The method of perfection depends nearly entirely upon the form of collateral. A security interest in automobiles, cars is usually perfected by indicating the security interest on the certificate of title itself, required in Florida. A security interest in equipment arises when the equipment, which is any good that is not inventory, farm equipment, or consumer goods, is perfected by the filing of a financing statement. A financing statement must contain the names of the debtor, contain the name of the creditor, and contain a description of the collateral. Ultra generic terms are fine, or terms used by the UCC. Let me just clarify that. Ultra generic terms. Right. The financing statement can have ultra generic terms, but the security agreement should not. Okay. Don't get lost in the sauce there. An accession is any personal property attached to another piece of personal property which merges into the former, such as a bike seat and a bike. A security interest in a truck. A security interest in a truck constitutes a security interest in all accessions affixed thereto. A security interest also attaches to any proceeds of the collateral, that is, other items or funds gained by the sale or use of the collateral itself. Generally, upon the default of a secured debtor, the creditor may exercise a right of repossession. Thus, upon default of the underlying obligation, the creditor may retake possession of the collateral for its own account, provided it can be done without a breach of the peace. A breach of this peace is not specifically defined in the UCC, but is generally construed as to mean the potential for violence or flagrant disruption of a civilized society. Any entry by a secured creditor into the home of a debtor to retake possession of collateral is per se breach of the peace, and the best interest of creditor given flourish stand your ground laws. Good point. As such, to repossess any collateral within the home of a debtor, the creditor must resort to remedies to replevy the good. In Florida, a secured creditor, when obtaining possession of collateral through repossession or by writ of replevin, has the ability to sell the collateral at public or private sale and apply the balance gained through the sale to the sums owed by the debtor. A sale of this nature must be commercially reasonable, which requires, among others, notice to the debtor of the date, time, and location of the sale. If a sale is commercially unreasonable, the creditor may not be able to recover deficiency. Under Article 9 of the UCC, there's a presumption that any public sale of the collateral would have resulted in full payment of the debt. Thus, in the event the sale price is insufficient to cover the debt, the burden shifts to the secured creditor to show that the sale was commercially reasonable. After any such sale, the creditor may hold the debtor personally responsible for the remaining balance via an in personam deficiency action. Lastly, a debtor has a right of redemption, which cannot be waived unless it's waived in writing after default. Thus, the debtor may exercise the right of redemption by paying the full balance due on the promissory note, together with fees and assessments accruing thereby, and recover the chattel. It's just like in a mortgage. In Florida, a breach of contract occurs when there's a valid contract offers under consideration. A security agreement is in and of itself a contract, and a party may be held liable for any breach of such an agreement. Under the terms thereof, a party may be entitled to damages commensurate with their expectation interest, the position they would have been had the contract been fully performed. And then you see this essay does a little bit on promissory note, which we remember is a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order a bearer with no additional undertakings. So that's, what an outline would look like. And then just kind of, oh yeah, we want to see two more things. Super easy. If you look at my student accountability course, I think I've been counting the most on Joel here. Let's see what we got for secure transactions. Ethics. So for secure transactions, what governs secure transactions? Article 9, what are types of collateral, consumer goods, equipment, farm products, and inventory. What is consignment? Giving a merchant goods with the expectation the goods will be sold, not giving legal ownership. Tangibles, consumer goods, inventory, farm products, equipment. If they're fixtures, part real estate, Article 9 applicable. Intangibles, tangible, intangibles, intangible, intangibles. Process of attachment. Gives value, has rights. Security agreement that sufficiently describes the collateral. Commingling, unidentifiable. Accession, identifiable. Security agreement, writing, authenticated. Granting clause, description of collateral. A pledge are the parties created from an oral security agreement. Process of perfection, we're going to usually do filing. We have automatic perfection for PMSI and consumer goods, PMSI non-consumer goods, 20-day grace period. What's a PMSI? Purchase money security interest. Automatic in consumer goods, 20-day grace period, non-consumer goods. Temporary perfection to proceeds of consumer goods, PMSI. Financing statement is how long? For 5 years, and within 6 months, you have to file for continuation. Remember that we need to file the certificate of title for motor vehicles. We need to include the name of the debtor, the name of the secured party, the description of the collateral. In Florida, you have to note it on the vehicle's title. Who has priority? Remember, it's first in time, first in right, except perfected versus unperfected, PMSI overall. And lien creditors are treated as perfected by definition. What happens if there's a default? Secured party has rights to repossess. If they cannot recover the goods without breaching the peace, they may need to bring an act for replevin. Super easy. That's why I said secured transactions. If you can just memorize this outline, you're going to do really, really well on this exam. So if it's tested. So the last thing I want to look at is just, see how it came up on the test on an official essay model answer. And we see it's really not that bad. They test secured transactions, commercial paper, and ethics 1 year. That was really brutal. Usually secured transactions is just tested as an auxiliary subject to another one. So this is the one we already saw. We went over and we talked about how there was a security agreement and a negotiable instrument. So you just got to know about negotiable instruments. Remember, this one was conditional. So one of them wouldn't constitute a negotiable instrument because it was now it's conditional. It was paid for in a car, not money. But that was the promissory note piece. The secured transaction piece here is well, he didn't even really seem to write about secure transactions here. He wrote all about Article 3 and not much about Article 9. Still got the model answer. So you see, it's crazy, right? We're going to write a great secure transactions piece. If we see any type of collateral, we're going to identify all the different types of tangible collaterals and intangible collaterals. We're going to do a beautiful walking the reader through the process of attachment, perfection, priority. We'll talk about what happens in terms of a default, and we're going to look out for a PMSI. So here, categories of collateral, Article 9 for tangible goods. Talked about here, the antique cars are most likely equipment, so they identified them. They'll be identified as equipment, blah, blah, blah. Attachment, security agreement for value, rights in the collateral. The uncle does not have a security agreement, but rather perfects with the certificate of title because it was a car. Remember, certificate of title on a car. Financing statement gives value for the security interest. and they discuss below perfection. So they just go through it, right? Attachment, they have a good article about whether there's attachment. He gives value. Where there's perfection, possession control, filing a financing statement, certificate title, automatic perfection. The uncle perfected with the title. This person, the collateral, they say, it could be ultra generic, it's permissible, and it's appropriate here. And then priority, they just go through who has the priority, when did they perfect it. It could be, for someone who's not prepared, and then repossession, you can repossess just without breaching the peace. And then you need writ of repleven. For someone who knows nothing about secure transactions and commercial paper, they get smoked by this essay. For someone who's watched my videos, who's come to my course and knows that all we need to do is just drop the main pieces of both, go through commercial paper. Is it a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order a bearer with no additional undertakings, and then see if they become a holder in due course. And, just going to go through that process, the fades, frauds in the factum, alteration, incapacity, infancy, illegality, duress, discharge in court, suretyship, statute of frauds, go through that whole process of, is this commercial paper? Has it been properly negotiated, bearer paper, order paper? And then, finally consider transfer warranties and presentment warranties. With the secured transactions, you'd say, okay, what's the collateral? You see, a lot of it's about identification. We need to identify a promissory note, commercial paper issue. We need to identify some sort of collateral, consignment, some sort of, Article 3 and Article 9. And once you identify it, it's very simple, just marching through. Here we have a security interest. How was it created? What are the different types of collateral? Then we go through security agreement, financing statement, which is perfection. We consider the PMSI. We go through the process of priority, think about what happens in a default, and end up with can't breach the peace. You got to seek a writ of repleven. And with that being said, that's secure transactions in a nutshell. Not extremely likely that it will be tested, but I think if it is tested, it's a subject that you can be confident in, because a lot of students totally blow it off. Whereas I like to run over it a few times, make sure secure transactions and commercial paper, if they come out on the essay, we're going to be a little bit relieved that we can thoroughly complete the essay, because we know the main ideas of secure transactions and commercial paper. So I really, really appreciate every one of you all. I wish you the absolute best on your test, and don't ever be afraid to reach out to me or anyone on my team for any reason at all. Thank you so much.